So in terms of the historiography, the book really intervenes primarily in three sets of historical literatures. One has to do with civil rights history, one has to do with our history of conservatism, and another has to do with how we write the history and understand the history of the Constitution. In terms of the civil rights historiography, again, those are the historians who say, well, there was this brief period in the 30s and 40s where African Americans were trying to win constitutional rights at work, but that kind of fizzled out once the Cold War started in the 1950s. And to that literature, my book is arguing actually African American workers and civil rights organizations continued. In fact, some of their fiercest fights for constitutional rights in the workplace happened in the 1950s, 60s, and 70s. So that there really was a much more vigorous fight for workplace rights, for rights on behalf of African American workers. That was part of the traditional civil rights movement, and that fight was happening in terms of the Constitution and constitutional civil rights, not just efforts to get laws passed and things like that. In terms of the history of conservatism, there's been a lot of great work on the history of conservatism. There has not been, in the 20th century United States, I would say recently, there has not been so much focus on how conservatives used the law, especially in the earlier or mid-20th century. I think we have some better idea of how conservatives used law in the late 20th century. And to the extent there is work on how conservatives use law, it is more in the area of religious conservatism or social issues, and not so much on the economic issue side of conservative movement. So the book is, I think, one of the first legal histories of conservatives, kind of business conservatives, economic conservatives, and one of the arguments I make is that they turned to the law early and often, and that in many ways a conservative civil rights movement grew up right alongside the liberal civil rights movement we're more familiar with. They were quick to adopt that rhetoric of civil rights and to frame their claims in terms of civil rights. They were using a lot of the same legal materials as liberal civil rights movements were, and so part of the, one of the arguments I make in the book is that we really should understand conservatives not to just sort of come along at the end and co-opted the liberal legal movements of the mid-20th century, but really to have grown up right alongside them. And then the last set of arguments, these ones about how, where we look for constitutional history, one of the arguments I make is that we really can't understand the full scope of constitutional history if we only look at the way people litigated cases in the courts and the way courts decided what constitutional law meant. And I find one of the reasons that people thought there was no advocacy around a workplace constitution in the middle of the 20th century was because we're looking primarily at courts, and it turned out a lot of that advocacy was happening in front of other government actors, particularly administrative agencies. And so one of the arguments I also use the book to make is that if we really want to write a robust constitutional history, we need to look at other locations in the government for where constitutional meaning is made than simply in the courts.